Greetings, and welcome back to the Elder Law and Guardianship Training video series for attorneys. The second video in the series explores navigating client relationships, educating clients, and zealous advocacy. Additional videos in this series will address alternatives to guardianship, limited guardianships, emergency guardianships, the use of a guardian ad litem, review hearings, and post-adjudication responsibilities. Let's begin by returning to the fictional law office of Miller, Jordan & Wise, as partner Charlie Jordan continues training and onboarding for new hire Avery Green. Charlie has assigned Avery to his first new client, Miranda Gonzalez. Mrs. Gonzalez is a widow whose adult children live too far away to be full-time caregivers. After Mrs. Gonzalez experienced a bad fall at home, resulting in a severe concussion, the local Area Agency on Aging, or AAA, filed a guardianship petition due to concerns with her ability to care for herself and handle her finances while living independently. The AAA representative noticed unpaid bills in Mrs. Gonzalez's home during a visit. The capacity hearing is scheduled for 6 weeks from now. Avery will be interviewing her tomorrow, and Charlie is checking to make sure he is ready.
So how are you feeling about your first client interview with Mrs. Gonzalez tomorrow?
Honestly, nervous and excited at the same time. I'm pretty confident from my research that she is coherent enough to carry on a conversation and is fluent in both English and Spanish.
What's the first thing you want to establish in talking with her?
Who I am, what I do, why I'm there. Make sure it's clear that I'm her lawyer, not a guardian, and that if she doesn't want a guardian, I can advocate for that.
And that everything you discuss
is strictly confidential and between us.
Why?
To put her at ease, to help her know that she can trust me, and to help her open up to me more.
Good. It's important to not just do what's professionally advisable. It helps to have a reason for doing so. Your authentic intentions will come through to her. You're not just trying to get information from her. You're trying to build rapport and trust. If she trusts you, she'll tell you more. And trust is earned, not expected. So much of this job relies on us building relationships with our clients. Make sure when you explain the foundational info, why you're there, why and how the courts are involved, what guardianship is, what's at stake, what the next steps are, that you work to explain that in a safe, clear, understandable, non-lawyerly way. Law school and working in courtroom settings trains us to communicate in a certain way. But we have to work on softening our rhetorical style for clients and the general public in these kinds of situations. I do think you will be able to do this well, but it's worth mentioning. Remind me about her family situation.
Her husband passed away last fall, and her adult daughter and grandchildren live in California.
Mm-hmm. And her daughter's involvement?
She's been happy to chat with me and offer information, but it's cost prohibitive for her and her family to move back here to care for her mother, and it's similarly cost prohibitive for her to travel. She said she wishes she could be more involved and more helpful, but cannot at this point.
Any siblings that live near Pittsburgh or in Western Pennsylvania?
Unfortunately, no. Her priest has gone with her to some of her doctor's appointments.
You're a good listener. It's one of the reasons you got the job. Ask her about her daughter and her grandchildren for sure. That might get her talking. And Avery, I know you know this, but I have to emphasize it. Let her talk. We learn so much from our clients if we just let them talk.
I can do that. Definitely. I want her to feel heard.
Ask if she has local friends she trusts who could be helpful too. Having some friends who are willing to help means supported decision-making might be an appropriate alternative to guardianship. Power of attorney would also be plausible in that scenario. We should start thinking about alternatives to guardianship from the very first client contact. Her family may not be local anymore, but it's possible she has something like chosen family beyond her priest.
Not sure if this is helpful, but she does have a cat.
That's great, actually. Ask her about her cat.
Really?
Is that going to be helpful information in the hearing? No, almost certainly not. But if she spends 5 minutes talking about her cat tomorrow, that might make her comfortable talking about things that are more important later. Let's see. What else did I want to mention? Oh, yes. What are you going to do if she starts to seem distracted or tired?
Wrap it up and schedule a follow-up conversation.
Very good, Avery. Another thing to consider, it's good to schedule follow-up meetings at different times during the day. Some clients experiencing any type of cognitive decline may be clearer in their thoughts earlier in the day and may show more signs of needing assistance later in the day. All that to say, if your first meeting happens at 3 p.m., try to schedule a follow-up meeting for 10 a.m. just to see if there are any observable differences.
Thank you. That sounds like research-based advice.
As a matter of fact, it is. Good luck. I think you're more than ready to do this, and I believe in you.
Thanks. With your preparation and support, I'm believing in myself as well.
Educating clients ahead of hearings is an important task for attorneys. Just as important is navigating the nuances of the attorney-client relationship. Charlie clearly has thoughts on how Avery can best build a relationship with his first client, Mrs. Gonzalez. Her advice centers around him developing an authentic rapport with her so that she will trust him and open up more. Avery is lucky that Mrs. Gonzalez is able to communicate verbally with a reliable degree of competency and accuracy. Some alleged incapacitated persons, or AIPs, are largely nonverbal or non-communicative. In those cases, counsel can, of course, interview family members or close friends to try and establish what seems to most closely align with the client's wishes. But establishing this is difficult if the client cannot directly communicate themselves. If an attorney has to determine the wishes and desires of a nonverbal or non-communicative client, they run the risk of inserting their own value judgments into the work, which is closer to the responsibility of a guardian ad litem, which is a topic we'll explore in more detail in the fourth video of this series. Our expert panel has even more perspectives to offer on navigating attorney-client relationships and educating clients.
I think that meeting with clients and really talking with them is essential. We will go to wherever the clients are. If they can come to our office, that's great. But if the client is in a nursing home, we'll go to the nursing home. If they're in their own home, we'll go to their home. It's often really helpful to see clients in their own environment to get a sense of, who they are and how they're living, how they're managing. So meeting with them face to face and then really talking with them. As lawyers, we tend to come in with a set of questions that we want the answers to. And sometimes our people need to tell you other things that are important to them. And one thing I've learned over the years is that you can try to redirect people, but often it's helpful just to listen to them and to hear about the things that are important to them, and then work your way hopefully from there to getting the information that you're specifically after. But I think it's really helpful to really just listen to our clients, to listen to their experience, to listen to what they are saying their needs are and their goals are and their preferences, and to let them know that you are there to help them achieve that as much as possible.
From the moment the client comes in, we always try to make sure that the client is comfortable. It's not a client meeting where someone comes in and immediately is being bombarded with questions, deeply personal questions about their health and their finances. So it can start with something as simple as making sure that the client is in a comfortable room, making sure they have a glass of water, making sure that they can hear you, you're sitting close enough and you're speaking clearly and you can be heard and understood. And then giving the client time to tell their story and listening attentively without interruption, allowing clients to share what it is that they're there for. And that allows you to better understand what their needs are, sometimes more effectively than peppering them with questions. Is just to listen to clients' stories and determine from there how it is you can best support them to achieve the goals that they came to you to achieve. I think the best client relationships are when somebody comes in with a problem that they want resolved. They're looking to perhaps plan for a future. If they're having a mental, physical, cognitive decline and they want to prepare, or they're worried about future decline and they want to prepare a plan for a time when they not be able to make a decision for themselves. And they come in with that goal and we're able to work with them to fulfill that goal. So when we're able to work with clients to meet their needs, to provide for them what it is that they came in for, a relationship where we respect each other, and there's a relationship of trust. Some of the challenging client relationships I've faced are when family members have goals that don't align with the client's goals, when the client and what's best for the client is different than what family members may want, and when family members try and insert themselves and impose their wishes on the client to fulfill their own goals and ends. It's important to remember that as the attorney representing the client and the client only, and other family members may not understand that, and it can be difficult to explain to family members who may or may not have the client's best interests at heart, that you are there to make sure that the client's wishes are fulfilled, and only the client's wishes are fulfilled. In my role, we try and catch clients before there's any hearing. So we're working with clients upstream to try and prevent them from having to have court proceedings or litigation in the future. But even though our work with clients is upstream, trying to prevent them from having court involvement later in their life, we still have to make sure that when we're working with them, they understand and have the capacity to draft the documents that we're creating for them, to prepare alternatives to guardianship in advance before a medical or financial crisis happens. Sometimes clients come to us when it's too late, when they've already lost capacity, when family members have started to get worried that their parent or their spouse can no longer take care of themselves. Then they'll come in looking for services to help that declining person. When it's too late, unfortunately, there's not much we can do. So that is a real barrier when people wait too long to come and see us to get those upstream services.
For many families, especially parents of children who have a disability, they see this process as adversarial. They cannot understand why is a judge and other court personnel making inquiries into our lives. All we want to do is care for our child. That's all we want. So please allow us to do that. When you try to explain to them their needs and why we have to do this, I can see them frequently becoming more relaxed if we talk about it at the outset. So I try to explain to the parents especially, we understand why you're here and why you don't want to be here and why you're questioning this process and what we're going to try and do to help you. On the flip side, we have many parents, when we talk about alternatives, they've already been told by everybody in the system, you need a guardianship, you need a guardianship, you need a guardianship. So if the judge isn't giving them a guardianship, then they start to question that. And then they want to know why the judge isn't giving them the guardianship of their child. So it's a significant educational process, especially for parents of children who have now aged into adulthood and no longer are seen as children. So that's one of the biggest misconceptions that I see.
I think one of the most common misconceptions about the guardianship legal process is that there are some people who come to court expecting that everyone, when they reach 18, if they have any kind of disability, needs a guardian. And under Act 61 from 2023, we're now required to inquire whether there might be a better way to solve the issues that are being presented without the need for guardianship. For instance, can the person sign a power of attorney or a healthcare power of attorney? Are there other healthcare decision makers? Can the family and other friends and supporters be part of a supported decision-making process for that person? Can the person retain their dignity and to some extent their decision-making without necessarily having a guardianship?
5 weeks have now gone by since Avery's first interview of Mrs. Gonzalez. Her capacity hearing is next week, and Avery will be representing her in court on behalf of the firm, his first solo courtroom representation on behalf of Miller, Jordan, and Wise. Naturally, Charlie has questions and advice. Let's listen in as Charlie challenges Avery to engage in zealous advocacy.
So, your first solo hearing is next week. How are you feeling about representing a client in front of Judge Morris?
Well, I feel cautiously optimistic.
Have we talked yet about zealous advocacy?
Not really. We've certainly talked about advocacy.
Okay, so zealous advocacy is our goal. I know you know Mrs. Gonzalez's situation in great detail. I know you have a rapport with her, and I know you're prepared to advocate for her wishes. But I want you to lean in on those points and make sure Judge Morris knows all of those things too, with clarity and distinction. What are you advocating for?
Her wishes. She wants to not have a full guardianship, but she does want some oversight and assistance on financial and healthcare matters. We're asking the judge to consider an alternative to guardianship that allows her to continue to make decisions with some autonomy, but with supportive people in place to help provide the degree of oversight and support she needs.
Great. Sounds like you're prepared to be a strong advocate for the wishes and plans that the client has articulated are her goals. That's the definition of zealous advocacy by an attorney. One thing to keep in mind is that serving as an attorney for a person who faces a guardianship petition is very different from services as a guardian ad litem, who will be appointed by the court to identify the best interests of a person who has a disability. An attorney, even a court-appointed attorney, does not work for the court. The attorney works for the client, and the goals of the representation must be determined by the client. I know you know this, but it's one of those fundamentals that's always worth noting. Have you and Mrs. Gonzalez discussed whether she wishes to testify in court?
Yes. She feels strongly she would like to testify herself, and that she would like to explain to the judge that she can continue making decisions for herself in a way that keeps her healthy and financially comfortable. And she wants someone to check her work, review her finances, and offer consultation, review her medical appointment calendar with her and medication plans.
Well, if that's the extent of her needs, then I can see why a guardianship may not be needed. A guardian does a lot more than that.
Right, like I said, cautiously optimistic. I noticed that she seemed more lucid in our second meeting and even more so in our third. So I am hopeful that may be a sign she is also just healing from the concussion symptoms and slowly regaining something closer to her full capacity already. She told me how she and her deceased husband worked multiple jobs for decades so they could feed their children, buy their house, and set aside a little money to save for the future. Financially, she's in pretty good shape. Her investment portfolio isn't massive, but it will help her get by comfortably. She's also planning to sell her house and to use the money from the home sale to pay for assisted living at Brooks Meadow Retirement Community.
And this is her plan.
She wanted something like this. I helped her do the research to figure out which living situation might best provide for her needs and meet her budget.
Is Dr. Montgomery testifying?
Yes, Dr. Montgomery told me, based upon her testing and interview with Mrs. Gonzalez, she has concluded that Mrs. Gonzalez has a capacity to make and communicate decisions and the ability, with some assistance, to manage most of her daily responsibilities. Dr. Montgomery also concluded that Mrs. Gonzalez has the capacity to sign a healthcare power of attorney, appointing an agent. So I feel we have strong evidence to present.
Excellent. And you told me you have some additional compelling evidence.
I'm planning to share 6 months of her financial records, medical appointment notes, and her organizational calendar. They're imperfect, but to me, her records clearly reflect someone much more on top of things than not, and I'm hopeful Judge Morris will agree.
It sounds like you're prepared to make a fairly strong case.
Again, cautiously optimistic.
Sounds like well-placed optimism. Your evidence is compelling, and I'd be surprised if the petition for guardianship isn't dismissed and an alternative to guardianship is identified. Judge Morris is well-versed in alternatives, and I've definitely seen him utilize them before. He's pragmatic and informed. With that in mind, however, zealous advocacy means that even if your case is strong, you don't get to be complacent or overconfident. You still have to make sure her case is clearly made and advocate with some intensity and focus for her wishes.
I think I know what you mean. That's helpful advice.
What about if the next one is different?
How do you mean?
Well, Mrs. Gonzalez is a fairly clear verbal communicator. What if your next client is nonverbal? What if they're in a coma? How can we zealously advocate for clients who perhaps are not so adept at advocating for themselves?
That would be more challenging.
I've had nonverbal clients, I've had clients in a coma, and clients who've had family members who were very eager to act as guardians, but not themselves trustworthy people. I've had clients who were told by doctors and nursing homes that guardianship was their only option.
Which is incorrect. Wow, it's meant to be a last resort.
Exactly. Sometimes very bright, well-educated people still get the wrong idea. There's a tremendous need for education at every level of guardianship world. And to be fair, the whole guardianship process is, as you are learning, quite complex. But to my larger point, people facing capacity hearings and the possibility of guardianship need our zealous advocacy more than almost any other clients, because many of them cannot advocate especially well for themselves.
Charlie wants to ensure that Avery is zealously advocating for the needs of his client. Understanding a client's wishes, advocating for accommodations that will help meet their needs, ensuring that their dignity can be upheld throughout the process. All of these are important objectives for counsel. Our experts will go into more as they share with us the do's and don'ts of zealous advocacy in guardianship cases.
Oftentimes when our clients come in to see us, they're coming in protect and plan for the well-being of their family, to make sure that their family's needs are met when they may not be able to take care of themselves or when they may no longer be alive. And so some of the important work that we do is making sure that the client is able to share information with their family to the extent that they're comfortable, to prepare their family for a time when the client may not be able to take care of themselves, for their family to be supported with all the legal paperwork and the documents that they need so that there aren't any difficulties in making decisions for the incapacitated client, and making sure that client's wishes are fulfilled in advance so that conflict and disagreement later in life is avoided. Every client who comes in has a story to tell. Everyone is part of a family, has people in their lives who are important to them, has decisions that are important to them. So listening to clients tell their story, listening to clients explain why it is they're there, giving clients space to express and share what their concerns are and why they've arrived at your office for estate planning and end-of-life planning is really the best way of trying to understand what it is the clients need and trying to make sure that you craft a plan that meets those needs.
Whenever we conduct a hearing and a person appearing before us has difficulty communicating, it's the responsibility of the court to make sure that if they need an interpreter, or if they need a hearing device, or something that the court reporter can provide them real-time transcript that they can read from, if that would be easier than for them to hear. We provide those types of accommodations in the courtroom. And it's very important that we make inquiry both before and at the beginning of the hearing to make sure everyone involved, including the alleged incapacitated person, has the ability to speak up and ask for the accommodations that they might need.
I think it is appropriate for a judge to ask the attorney representing the individual, what are their needs? And hopefully the attorney can tell us with certainty what they need. And it could be that they need a listening device. It could be that they need everyone in the room to just speak a little louder. It could be that they need to have some things repeated. And the thing in all those instances is to have the time set aside, that you don't feel as if you're looking at the clock to say, I've got another hearing in another half an hour and we need to keep moving. You need to be able to say, we've got the time to stop and accommodate people. That's probably the biggest thing that I think as a judge we can do, is to tell everyone we can slow down and that we can take time. That's the most important thing.
It's very important when we begin a court proceeding, and actually before the court proceeding, to learn whether any of the participants, particularly the alleged incapacitated person, has any hearing deficit or needs an interpreter for language or for any other reason. I have had in my courtroom the use of assisted listening devices, the use of a court reporter making a transcript in real time that can be read by someone who's having a hearing deficit. And we also have had interpreters in many languages, including American Sign Language.
Yes, frequently we will find that individuals have limitations in hearing. And when that occurs, we need to make sure that they are able to hear. And sometimes what is a concern for me is you realize that lack of hearing may actually have affected the evaluations that were conducted. And so it's very, very important for us to be able to assure ourselves, especially as judges, that the person is not able to communicate well with us because of maybe a lack of capacity as opposed to a lack of hearing. So if we can resolve that at the outset, that's a good thing.
I've had so many excellent attorneys appear before me representing an alleged incapacitated person. Countless times I've seen attorneys make a meaningful difference in advocating for their clients, and particularly as in this new era we're looking more and more to identify alternatives to guardianship or ways we can craft a limited guardianship order. Attorneys are absolutely essential to helping the court and their client craft those less restrictive alternatives to guardianship. I've also had attorneys, I think, sometimes fall short of the mark of zealous advocacy, and in particular, where attorneys feel a little bit of conflict and feel that their client is insisting they don't need a guardianship, and the attorney may have some concerns about them. I've sometimes seen attorneys take on the role of the petitioner when really their obligation is to their client and to advocate against the guardianship if that's what their client wishes. I think attorneys need to know that they can trust the court to hear from both sides, and the court will ultimately make the right decision after being presented with all of the facts. But in our system, they do have a role, and it's an important role, to maintain their relationship of trust and respect for their client and to advocate for what their client wants to see.
Let me start with falling short. Falling short is to walk in and to tell the judge, I already know what's in this person's best interest, and I'm just going to tell you that. And that's the end of their representation. And that can still occur. So as the judge in the case, I need to remind the attorneys that it's not frequently that simple. The other thing is to, in advance of the hearing, give everyone guidance of expectations. So to that end, it is good to remind the attorneys of the guardianship statute and what the court is expecting to hear in a hearing, especially alternatives to guardianship and or if the person has capacity or not. What does that mean? Make sure that they can be fully conversant on those topics. There are attorneys who really do take the time to do a lot of investigation and seek answers to all those questions, and then be able to say those, or to make argument to the court. And that kind of zealous advocacy can lead to then hopefully really good choices being made by the court. And they help make a record for the court in support of its decisions. That is where I see great advocacy. It should never be, in my view, seen as, well, I was able to prevent guardianship. It should be, I was able to secure the best results for my client, no matter what they may be. And best results frequently can be a combination of alternatives to guardianship, but sometimes there is a need for guardianship. So I think, to me, the best advocates are not walking into the courtroom with a preconceived idea of exactly what that result will be.
I think it's important to remember that the client in the meeting knows their life better than anyone else. They are in charge of their own autonomy, they're in charge of their own decision making, and they know their family best. They know who's best positioned to make healthcare decisions for them, to make financial decisions for them. We act in the role of advisors and counselors. We can give guidance and suggestions, but ultimately the client knows their family best, and it's up to them to decide who they want to make decisions for them.
I always think it's important that the alleged incapacitated person knows they have a voice and a right to be heard. We need to listen to an alleged incapacitated person, whether an older adult or a younger adult. And sometimes they are the person best suited to explain what they need and what they feel they don't need to assist them. So I think it really starts with giving them voice and listening.
Well, first of all, I try to address the AIP at the beginning, if I can, get a sense of how they're feeling. We have a great group of attorneys in our community who really do strive to get to know the client. I think they take a lot of pride in that. And hopefully what we try to do is, to afford them the chance to speak, afford them the opportunity to ask questions. Try to do our best, though, too, that if they are uncomfortable, we can stop the proceedings. We can allow them some time to maybe adjust. If they need to receive medications or things like that, we can accommodate that. In today's world with video, we're able to normally allow them to remain sometimes in the environment and where they're living, and that reduces stress. Of course, it's important for us to understand what that environment is all about. It is not uncommon at times if I have been told that the individual really is not able to be moved. We can schedule a special hearing, and I go to the facility and I take time to meet them at the facility and get to see exactly what they are experiencing, from entering the doors, walking through the hallways, seeing the environment, meeting with them. And that gives me a chance to observe frequently the proposed guardian's interaction too, the staff with the individual. And that sometimes can be reassuring to me that everything's okay. And of course, if I think that the facility's not doing a good job, then we could talk about that too. So those are things that I've seen.
Giving clients the best chance to communicate their perspectives successfully, ensuring their dignity, and zealously advocating for the outcome that most closely aligns to their wishes. All of this is a critical part of the job of counsel. Thank you for watching part 2 of our series. In part 3, we will watch Charlie and Avery grapple with and hear our experts comment on alternatives to guardianship and limited guardianships.